Aloha, everybody, and welcome to this episode of the Triple F podcast, Faith and Family First. Jim and I are going to talk about 706 uncured and deficient returns in the 2022 election on Maui and what the Supreme Court said about that. We'll be right back. All right, Jim, welcome to the show today.
Hey, so I think we need to mention you got sick, so we didn't get to do our regular studio recording. So we're cheating with a little Zoom right now, but
I know we have to give Zoom backgrounds some upticks. All right, so Jim, one of the interesting conversations that I've been having recently with people, because you know just as well as I do that we've got a lot of people in our constituency that are not happy that we went to an all mail-in ballot system, right? So you've got people that have been saying since we did that there are problems, that votes are not being counted. They think there's some shenanigans going on. And two candidates on Maui ran into a little bit of a problem. Well, I would say one of the two candidates felt there was a problem because there were 706 spoiled ballots, technically. And they asked basically the election to be thrown out in their particular race because there were about 513 differences in the vote between the one that
actually they asked for it to be thrown out because they didn't win.
Well, yes, but when they looked at the overall numbers, so they looked kind of at it in a general way, right? There's 700 plus spoiled ballots. And I lost by 513 votes. So with those spoiled ballots out there, there is a chance that I could have won. And the two candidates were Alice Lee and Noelani Ahia. And I think she was on the ballot as J. Noelani Ahia. So they sent this case to the Supreme Court, and there were like 31 people that were on this. Okay, 30 that were on this particular case, which I thought was pretty amusing that there were that many people that thought that there was a problem that needed to be addressed in this.
Well, it's a little bit more specific than that. There were 31 plaintiffs because Ahia, as the failed candidate, is the named plaintiff, the first one in the list. But then she had 30 of the people that were voting for her as plaintiffs as well.
Right.
So that's why there's 31. But they weren't just people, they were actually aggrieved voters.
Yeah. So you mention this all the time when you talk about the potential of any court case. You have to have somebody who was hurt by something in order to go and sue, right? So these
Correct.
People claim that their votes may not have been counted, or I'm not sure that maybe they were the ones that when they got their ballots returned, they didn't feel like they were counted. This particular proceeding that I read through didn't say that specifically, but in any case, you've got 30 aggrieved people. So in case people are watching and listening, they may not understand, when people get a ballot in the state of Hawaii, they get an official ballot, they get a return identification envelope with postage prepaid, they get a secrecy envelope or a secrecy sleeve, however you want to word that, and they get instructions. Okay. So what happened was, the election happened, so the mailing starts going out, people start getting their envelopes, and then they have to, send it in. Now, according to this particular case, beginning October the 26th, they got 6 ballots that were reviewed that they found were faulty, and they have a process so that they have to go and try and find out, whatever it is. Is it missing a signature? Whatever the issue is. So the clerk has to go back to the voter and give them time to come back and say what the issue was, right?
So is this without opening the return envelope? They're just looking at the envelope and the signature because what we do is we have to sign. Well, when you lick the back of the envelope to glue it down, then there's a place to sign across that glued down area. So at this point, they had opened that envelope, or they were just comparing the signature with the election signature?
They don't specify. According to the particular case, it says that the clerk reviewed all of the return in identification envelopes submitted by the voters and the number of return identification envelopes reviewed each day. So
that means they didn't open the envelope that had the ballot. They aren't knowing who you voted for. They're just looking at your return envelope to see if it qualifies.
Right. So as they're going on to explain it a little bit more, they're saying with respect to the total number of return envelopes, which they're saying was about 15,000, the clerk reviews a bunch of them, and some of these were reviewed into the early morning of November 9th. And the clerk is looking at all these things and she's deciding what she's going to return. And the problem was that from all the return identification envelopes that were received from the voters, the clerk determined that 865 were deficient based on one of the grounds set in Hawaii Revised Statute 11-106, including an unsigned affirmation, an affirmation signature that did not match a reference signature image, or another condition like a tampered ballot. And then it says that for all 865 of these voters, the clerk mailed a notice to each voter that informed the voter of the deficiency and provided information on how to cure the deficiency. So basically, they give a list of all these notices that were returned of all of these 865. Now, the court.
Well, before you move on from there, what you're talking about, the notice to cure the deficiency, what that means in non-legal language is, hey, Eva, we looked at your return envelope. It's not qualified. It has a problem. You have so many days to fix it, and then we can count your vote if your ballot is correct. So that's what they were giving notice to come fix your envelope.
Right.
And I just want to make sure we understand that.
No, that's great. Okay. Now, when they did that, 159 people timely responded. Okay. So the case continues that at the end of the review period, which was November 14th, so this is after the election, they ascertained that there were 706 uncured and deficient returns, which is the number I gave at the earlier.
Which means they weren't going to count those ballots because they weren't going to open them.
Correct. Okay. So now,
one other interesting thing too, factually, Miss Ahia and Miss Lee were running for the Maui County Council. But on Maui, just like on Oahu, when you go to vote for your city council member, it's on the same piece of paper with all your other candidates for all the other seats, which means all the people running for any office on Maui or in the state legislature from Maui or for governor voting from Maui or running for Congress or the Senate representing Maui, all of those 800 ballots were wrong for all of those, but only Miss Ahia challenged it. I just wanted to make people realize that.
That's a really good point. Yeah. So I think it goes back to the thing we always talk about, right? That during an election, people really, first of all, when you're voting, you've got to slow down. I know a lot of people, they've got the ballots in front of them. If they know who they're going to vote for, they do it quickly. And, some people are just trying to get the, check that off of their to-do list. And so like not having the proper signature and all that, it's like, come on, people, we can do better, right? Now, what's of the 215 remaining, the clerk received the ballots, right, no later than November 8th. So I want to keep that in mind.
The envelopes.
The envelope, but they have until Saturday, right, November 12th, according to Hawaii Revised Statutes, to mail the notice to cure. Okay, so this is what's interesting. So on the election day, right, one of the candidates who lost had a problem that the clerk did not, answer these questionable ballots in the proper time, right?
But that was only 215.
Well, yes. Okay. And I know that we're throwing out numbers, and we'll make the link to these particular documents available so people can read through, because Jim
And people really need to read both of the opinions.
yeah,
There's a majority opinion by 4 of the 5 Hawaii Supreme Court justices, and there's a dissenting opinion by the 5th justice who did not agree in the result, and he read the statutes differently. And it's a great opportunity with a pretty simple case for everybody to get a chance to read a Supreme Court decision where the dissenting opinion criticizes the majority for their wrong view. It's actually happens all the time, but this one's simple enough. Everybody should read it from the links.
It's really good. And we're going to give Jim an opportunity to talk about that dissenting view, because what I'm reading from is from the majority view. So all of these points that I'm going over are in this majority opinion. So, when Jim gets to why one of the judges felt differently, I really felt like we needed to do a show, because as Jim points out, it's a really good way to look at the process here in Hawaii, and why we really need to take elections more serious here in the state. And
it's also, I also thought we should do it specifically because in the last election cycle, and maybe the one before that, but I'm not sure. I think it maybe just the last election cycle. There was a lot of information in the news about candidates unhappy with the result, trying to litigate it and doing it wrong. And these guys at least did it right, but they lost anyway.
That's right. Okay, so the gist of the case, right, is that you've got somebody who loses by 500 plus votes, but there were 700 plus problematic ballots, some returned, some not. But part of the complaint was that the clerk did not respond on those, as you're moving closer to the election, right? The clerk would have to act very quickly. By the time the election comes, they have to get these ballots that they feel are problematic, and they have to get them back to the people so that everything can be done by their deadline. And in this case, the complaint was that on election day, the clerk election officials were providing assistance to voters at the voter service center. So they were unable on that day to garner the ones that had come in for that day that had problems, and some that had been mailed up to that point that had problems. Then the following day, which was November 9th and November 10th, the clerk still didn't get to it. And they're claiming that it was because they were dismantling the voter service centers to return the facility to another department. So basically they were doing housekeeping and tearing everything down and doing taking care of all of the election equipment. And then November 11th was a federal holiday.
Before you get to November 11th, there's another way to look at what they chose to make more important. The clerk on Maui decided it was more important for her to take care of the government need with respect to facilities and equipment than the voters' constitutional right to vote. That, to me, is really where the rubber hits the road here.
And these people that filed this complaint felt the exact same way. And so, Jim, that's a really good way of explaining that. So on November 11th, they didn't do anything because it was
a holiday. That's 11/11,
right?
Like Veterans Day,
right? So there were 215 notices according to this case that were not dealt with until after November 11th. Now that means that the quick turnaround to get to the deadline is very, very, very quick. And again, that deadline was November 15th. So there were 4 days. Well, if you put it in the mail on the 12th, they may not get it right till the 13th or 14th, which technically means they'd have to turn it around in a day. But
they actually didn't put them in the mail until the 15th, which means they arrived on the day the return was due.
Right.
That's what the 215 problem was.
Okay. And then another one of their challenges that they had was that, so in addition to all this delayed mailing issues that they have, they were also challenging the decision of the clerk to withhold the names of the voters because they wanted to know who these voters with the deficient return were because they wanted to follow up. And the clerk basically said, absolutely no. And she did this both verbally and written that she was not going to provide that information. And so that was.
And now the interesting thing about that point too is that they lost because the 4 out of the 5 justices decided the only evidence that clearly shows failure to meet the requirements of doing these envelope fixes was the 215 on the last day. They didn't get mailed until the 15th of November. Had the clerk given the names to the candidate after election day, when they knew she only lost by less than 600, she could have followed up and found more voters whose ballots didn't count who could say they voted for her, and then the outcome would have been different because the evidence would have been she actually would have won if they counted those votes.
Mm.
And they don't talk about that in the opinion. You have to read that between the lines.
Right. Yeah. Yeah. So, so just very briefly now, I'm just going to go over the points that the majority came up with, and then I'm going to let Jim take the last few minutes to go over what the dissenting opinion was. So basically, what the majority said is that regarding the 215 votes that were mailed, they did conclude that the clerk did not make reasonable efforts to determine the validity of those ballots. Okay. But then they come back and say, but with 215 votes, that wouldn't change the outcome of a 500 or so loss. Okay. So they also said that they were not persuaded by the clerk that it was reasonable to prioritize other work over contacting voters. Okay. So the majority agreed with Jim that the right, and they quote this, and this is from Okazaki versus Fong. It says the right to vote is perhaps the most basic and fundamental of all the rights guaranteed by our democratic form of government. So they agreed with that. And they also—
And by the way, that's why Citizens United was decided that corporations have free speech rights to contribute to candidates like people do, because the people in the corporations are voters.
Exactly. So the majority are finding that it was an error to delay the 215 notice to cure to voters. So they definitely based on that. But the bottom line is that they don't believe that these 215 voters would have changed the outcome of the election. And so that was basically their bottom line. So Jim, now, as Jim has mentioned in other shows, you've got a majority opinion in some of these court cases, and then you might have a minority opinion. Sometimes you get unanimous, but in this case, one of Hawaii's Supreme Court justices decided that the majority opinion was wrong. So Jim, explain why.
Okay, so he looked at the statute that says in Hawaii's election tabulation, there's a presumption that every ballot is valid, and that the elections office has to take reasonable steps. If they are concerned that it may not be, they have to take reasonable steps to validate or invalidate the ballot. And the majority said they didn't take reasonable steps by closing down to move furniture and then having a holiday, blah, blah, blah. And so the majority said the unreasonableness was only the 215. But what Justice, gosh, I can't remember his name. I know who he is too. But anyway, the dissenting justice said, if they were unreasonable, then all of the ballots that were counted have to be presumed valid. And therefore, there were more than enough uncounted votes to change the result. But the thing that bothered me about the majority opinion is the language of the statute says that in establishing a mistake by an election official that would cause a difference in the election result, that is the test under the statute. And a difference in the election result, the results of the election are a number of ballots for candidates and a number of spoiled ballots and a number of uncounted ballots. A difference in that result, by its own language, doesn't have to change who got elected. But the Supreme Court said that it means a difference sufficient to overturn the final election result. That's not in the statute. that is not in the statute. And so I don't think the court ought to be adding definitions in a statute that the legislature did not put there. Myself.
No,
That's just for myself.
Was Wilson the dissenting opinion?
Wilson, yes.
Okay.
Yes. And in fact, he's spoken several times at the Christian Legal Society luncheons that we have in Hawaii. He's a believer.
Oh, maybe we should get him on a show one of these days.
Not that matters in the way that the case was done. But the other thing with respect to refusing to, that's just for myself.
Was Wilson the dissenting opinion?
Wilson, yes.
Okay.
Yes. And in fact, he's spoken several times at the Christian Legal Society luncheons that we have in Hawaii. He's a believer.
Oh, maybe we should get him on a show one of these days.
Not that matters in the way that the case was done. But the other thing with respect to refusing to give the information for the candidate to go and find sufficient plaintiffs, because if she had 500 plaintiffs, she would have been able to prove to the majority that the election should be redone. And she wasn't asking that she win. She was asking for a new election. And that's something that we need to keep in mind. But what the court said is that withholding those names of the people with the deficient ballots was whether it was voted materials or whether it's something else. And the question was, whose ballots don't count? And the majority said that's not public record. Who's voting and who's not voting when you're a poll watcher, because I've been a poll watcher, and when you're a poll watcher, you work for a candidate or a party, or you're an independent poll watcher working for the government. And the poll book is the list of people that you sign your name on to get your ballot. And that is open and available to the poll watchers all day long during election day. And every hour, I would go look at the poll book to see who newly signed in and got a ballot, because I have a list of voters for my candidate. And I'm checking off the ones and calling party headquarters and telling them these people just voted. They're taking the information to contact the people who haven't voted yet, tell them go vote. So that, the majority said, is public information because the government doesn't provide it. But the government does provide it because the poll book is owned by the government and it's being written on by the people voting in the government polling place on election day. So I really don't think that she should have been prohibited from knowing who wasn't allowed to vote because of their envelope. I think that was wrong.
Well, Jim, in this last few minutes, and if there's any point that you want to make, definitely make it. But in these last couple of minutes, you and I were just talking, right? Because the legislative session is now in full swing, and you and I have been smiling and nodding at some of these bills that we are tracking this week. Just this week, Jim, there are 4 abortion bills and 1 assisted suicide expansion bill that are hearing. And you made a comment about how, and if we had the ding again, talking about elections, all of these problems with elections, why do we care so much about elections? Because the people that win end up making decisions that will affect you and me and our kids and our grandkids to come. So what are your thoughts on that?
So I'll take you a step farther and I'll raise you another $1.
Got it.
In SB 1, which is being heard on February 1st, it actually says in the hearing notice, you only get 2 minutes to give your testimony on a bill related to abortion.
Oh, wait, but tell them the sentence that happens before the 2 minutes.
Well, before, it's in the same paragraph. What it says is that the chair may limit who's allowed to testify and for how long. And right now, you're only going to get 2 minutes. And so what bothers me about that is their presumption as committee chairman, sending out hearing notices that they have the political power to tell us how much we can speak or whether we can speak at their hearing on a bill that's very controversial. Now, the way the hearing schedules are set is the president of the Senate, the Speaker of the House, the leadership of both the House and the Senate, in advance say hearings are going to be X period of time for the whole session. And so the chairman is stuck with that. But if the chairman didn't want to be stuck with that, they could make hoo-hoo when the decision is made and not just accept it. But I would guess, because I've been to hearings that last 4 days, they don't like to spend that much time. It's hard work. They have to act happy for a very long time in front of everybody because they're running for election again.
Okay,
it's not fun. I know we're running out of time.
But to be fair, you and I have participated in hearings where somebody will take 15 minutes and they won't even be talking about the bill. You know,
that's completely different, because if somebody's rambling, if it's not helpful, I have no problem with the exercise by the chairman of saying, you know, we need to move on to the next person here. Do you have something pertinent to say real quick in closing?
I have no problem. I have seen them do that.
But here's the problem. And the problem is the political power in this state is not owned by the politicians. Each politician that's alive and breathing has exactly the same amount of political power as you do, as I do, as everybody listening to this show and watching this show. Every voting eligible citizen has one vote, which is all the political power anybody has. They're abusing our political power by limiting that in how long we can testify, because we also have the constitutional right in Hawaii to assemble and petition the government for redress of grievances. And if they want to pass a bill making abortion more dangerous for women, which is what they're doing, in my opinion, and they know it's going to be controversial, doing this 2 minutes per person thing is not acceptable. I will be very nice and polite. It's not acceptable because they are the ones proposing this language. And we get to tell them what we think.
And the bottom line, people, is that Jesus tells us to render unto Caesar what is Caesar and to render unto God what is God's. We have a duty and a responsibility to raise our voice, not only during the elections, but when the legislative process is going on. We have to make sure that we are raising our voice, that we keep our legislators held accountable for what they're doing at the Capitol. So thank you for spending this time with us. We'll be back next week. Jim and I will be doing a couple of great interviews, one on marijuana and another one on some of this gender identity stuff. So you want to stay tuned to what's coming up. Jim, thanks so much for showing everybody. Jim, thanks so much for showing. Jim, thanks so much for showing up today. Make sure you like, subscribe, share, and like this video. And if you're looking to partner with us to make this podcast happen, send me an email at info@hawaiifamilyforum.org. Mahalo, everybody. We'll see you next week.
Aloha.